I have more respect for a man who lets me know where he stands, even if he's wrong.
We always said in Black Panther Party that they can do anything they want to us. We might not be back. I might be in jail. I might be anywhere. But when I leave, you can remember I said with the last words on my lips that I am a revolutionary.
New Nubian.
Legal Ethics and Professional Responsibility, presented by Dr. Jonah Sanders. Course objectives: to provide learners with a comprehensive understanding of legal ethics, professional responsibility, and the standards governing lawyers' conduct to ensure integrity in the legal profession. Course outline: Module 1, Introduction to Legal Ethics. Module 2, Lawyers' Duties to Clients. Module 3, Duties to the Court and Legal System. Module 4, Professional Responsibility and Practice Management. Module 5, Ethics Violations and Discipline. Module 6, Case Studies and Review Quiz. Course syllabus module topics covered: Time Learning Objectives 1, Intro to Legal Ethics Definition, History, Sources 20 minutes. Understand the Foundation of Legal Ethics 2, Duties to Clients, Confidentiality, Conflicts, Communication 25 minutes. Learn Lawyer-Client Ethical Obligations 3, Duties to Court Candor, Fairness, Misconduct 25 minutes. Know Ethical Duties toward the Justice System 4, Professional Responsibility Practice Management. And conduct 25 minutes, Manage Ethical Practice Responsibilities 5. Violations and Discipline Ethics, Breaches and Sanctions 15 minutes. Recognize Violations and Disciplinary Measures 6. Review and quiz scenarios plus test 10 minutes. Apply ethics concepts through case studies. Module 1, Introduction to Legal Ethics. Section 1. Definition and Importance of Legal Ethics. What are legal ethics? Legal ethics refers to a set of moral principles and professional standards lawyers must follow. It governs behavior in client representation, courtroom conduct, and general legal practice, ensuring accountability, integrity, and fairness in the justice system. Objectives of legal ethics. Legal ethics aims to protect client rights, uphold justice, maintain professional integrity, and reinforce public trust in legal institutions. It ensures lawyers act in a responsible, honest, and competent manner while fulfilling their legal duties. Key ethical duties of lawyers. Lawyers must act with competence, diligence, confidentiality, loyalty, and honesty. They are required to avoid conflicts of interest, communicate effectively with clients, and represent them zealously within the bounds of the law. Ethics versus law. What's the difference? Law sets enforceable rules. Ethics involves professional conduct beyond the law. A lawyer might act legally but unethically, like overbilling or withholding key information, thus breaching their duty even without violating the law. Importance for clients. Clients rely on lawyers to protect their rights. Ethical conduct ensures client confidentiality, informed consent, loyalty, and access to justice. A breach can severely harm clients' interests, both legally and personally. Importance for lawyers, lawyers' ethics ensures a credible and respectable professional identity. Ethical behavior helps avoid malpractice suits, disciplinary action, or disbarment, and enables long-term career success with integrity. Confidentiality in practice. Lawyers must protect all information related to client representation. This duty remains even after the case ends. Disclosure is allowed only with consent or when required by law, such as to prevent harm. Conflict of interest. Lawyers must not represent clients if there's a significant risk their interests conflict with another client or the lawyer's own interest. Conflict checks and disclosures are critical to avoid ethical violations. Duty of competence and diligence. Lawyers must have the necessary legal knowledge, skill, and preparation. They must act promptly, meet deadlines, and avoid negligence. Incompetent representation can harm clients and lead to ethical complaints. Honesty and candor to the court. A lawyer must never lie to or mislead the court. This includes presenting false evidence or concealing important facts. Ethical duties demand respect for the judicial process above personal or client gain. Impact on public trust. Ethical behavior builds trust in the legal profession. Misconduct, like corruption, client exploitation, or dishonest advocacy, erodes public confidence and weakens the credibility of the entire justice system. Consequences of ethical violations can lead to disciplinary action such as censure, suspension, or disbarment. Serious misconduct may even result in criminal prosecution or civil liability, damaging both career and reputation. Section 2. Historical development and key sources. Early roots of legal ethics. Legal ethics emerged from professional customs in English common law. Early lawyers followed unwritten rules of honor and integrity before formal codes were established in the 19th century. ABA Canons of 1908. The American Bar Association introduced the Canons of Professional Ethics in 1908. These were the first formal guidelines outlining duties of honesty, loyalty, and fair dealing for American lawyers. Limitations of the canons. Though foundational, the canons were criticized for being vague and outdated. They lacked detailed rules for modern legal issues, leading to the creation of more structured ethical codes later. ABA Model Code. The ABA replaced the canons with the Model Code of Professional Responsibility. It included ethical considerations and disciplinary rules, improving clarity and adaptability. ABA Model Rules of Professional Conduct in 1983. The ABA introduced the model rules, modern, detailed, and better suited to address complex legal practice. Most US states have adopted some version of these rules. Why the model rules matter. The model rules provide a national standard, guiding lawyer behavior across jurisdictions. They clarify issues like confidentiality, fees, advertising, and conflicts of interest, offering structure in ethical decision-making. State-level adaptations. Each state adopts and modifies the model rules. While most rules are similar nationwide, lawyers must follow the specific version enforced in the state where they practice. Enforcement mechanisms. State bar associations enforce ethics through complaint systems, investigations, hearings, and disciplinary boards. Lawyers must also complete continuing legal education in ethics. Role of ethics committees. Ethics committees provide advisory opinions when rules are unclear. These non-binding opinions help lawyers navigate ethical dilemmas without violating the rules. Judicial ethics codes. Judges follow their own ethical code, such as the Code of Judicial Conduct. It ensures impartiality, integrity, and avoidance of bias or political influence in decision-making. Evolution of ethics in law. Ethical rules continue evolving with technology, globalization, and shifting societal norms. New challenges include social media, virtual law offices, and cross-border practice. Critiques and challenges. Critics argue the ethics system may be too lenient, self-regulated, or biased. Others call for greater transparency, client protection, and accountability in lawyer discipline. Section 3. Role of ethics in the justice system. Lawyers as guardians of justice. Lawyers serve not just clients, but the legal system. Ethics ensures they don't manipulate facts, suppress evidence, or act in ways that obstruct justice even under client pressure. Prosecutors' ethical role. Prosecutors must seek justice, not merely convictions. They must disclose exculpatory evidence, avoid misleading the court, and protect the rights of the accused. Defense attorneys' ethical role. Defense lawyers must provide a strong defense regardless of the client's guilt. Ethics requires them to maintain confidentiality and challenge the prosecution while staying within the law. Judges and ethics. Judges must be impartial, disclose conflicts, avoid public political statements, and act with fairness. Even perceived bias can damage trust in the court's integrity. Ethics in civil litigation. Civil lawyers must avoid frivolous claims, engage respectfully with opposing counsel, and promote fair settlements. Ethics limits aggressive tactics that harm justice or clients. Ethics and legal fees. Lawyers must charge reasonable fees, avoid hidden charges, and clearly explain billing. Overcharging or misleading clients about costs is a serious ethical breach. Ethics in legal advertising. Lawyers may advertise services but must avoid false, deceptive, or misleading claims. Ethical rules balance free speech with protecting the public from misinformation. Technology and confidentiality. Email, cloud storage, and digital tools must be used responsibly. Lawyers must secure client data, use strong encryption, and understand tech to remain competent and ethical. Pro bono and access to justice. Lawyers have a moral duty to offer free or low-cost services to those who cannot afford legal help. It promotes fairness in the justice system. media and high-profile cases lawyers must balance media engagement with confidentiality. Public statements should not prejudice legal proceedings or violate ethical rules, especially in high-visibility cases. Corporate and government lawyers. They serve institutions, not individuals. Their ethical duties include reporting internal misconduct and protecting the organization's interests while maintaining legal and moral boundaries. Ethics in legal education law schools incorporate ethics into core curricula. Students learn rules of conduct, case studies, and role-play scenarios to prepare for real-life ethical dilemmas in practice. Section 4, Summary and Reflection Recap of Key Concepts Legal Ethics ensures fair, honest, and competent legal practice. From confidentiality to conflicts of interest, each rule helps uphold justice, protect clients, and maintain public confidence in the legal system. Critical thinking and discussion. How should lawyers handle unclear ethical dilemmas? What happens when ethical duties conflict? Are current rules strong enough to ensure justice? Explore these questions to deepen your understanding of legal ethics. Module 1, Introduction to Legal Ethics. Section 1. Competence and diligence overview of lawyers' duties to clients' lawyers. Owe clients duties of competence, confidentiality, loyalty, communication, and respect for decision-making. These duties build trust and protect clients' legal interests throughout representation. What is competence? Competence means having the legal knowledge, skill, thoroughness, and preparation necessary to handle a client's case effectively, in accordance with professional standards. Assessing legal competence factors include complexity of the matter, lawyers' training and experience, available resources, and ability to research or associate with experts if needed. Continuous legal education. To stay competent, lawyers must pursue ongoing legal education, stay current with laws, rules, and technology, and understand developments in their practice area. Risks of incompetence failure to act competently can lead to harm, malpractice claims, and disciplinary actions. Clients may lose legal rights due to poor representation. What is diligence? Diligence requires prompt, thorough, and committed representation. Lawyers must meet deadlines, follow through on obligations, and advocate effectively, even in difficult or slow-moving cases. Delays can cause serious harm. Lawyers must respond to clients and courts promptly, avoiding inaction that could damage the client's interests or case. Workload and diligence. Taking on too many cases may compromise diligence. Lawyers must manage their caseload to ensure each client receives proper time and attention. Supervision and delegation. If delegating tasks to paralegals or junior lawyers, the responsible attorney must supervise and ensure competent, diligent performance on behalf of the client. Ethical breach consequences. Failing in competence or diligence may lead to bar complaints, lawsuits, or even loss of license, especially when harm to the client is proven. Section 2. Confidentiality and attorney-client privilege duty of confidentiality. Lawyers must not reveal information relating to client representation, regardless of source or format, unless the client consents or disclosure is legally required. Scope of confidential information. Confidentiality covers all communications, facts, strategies, and even information learned indirectly during the attorney-client relationship, whether oral, written, or electronic. Duration of confidentiality. This duty continues even after the lawyer-client relationship ends, and even after the client's death, with rare exceptions permitted by law. Exceptions to confidentiality: lawyers may disclose information to prevent reasonably certain death, serious bodily harm, or substantial financial injury due to client's crime or fraud. Protecting digital communications: lawyers must use secure email, encrypted messaging, and protected storage systems to keep electronic client data confidential and prevent unauthorized access. Attorney-client privilege: a legal doctrine protecting confidential communications between lawyer and client, made for the purpose of seeking or giving legal advice. Privilege versus confidentiality privilege applies only to specific communications and is narrower than the general duty of confidentiality, but it offers stronger protection in court. Waiver of privilege: if the client shares privileged communication with third parties or fails to keep it private, the protection may be waived, intentionally or not. When privilege doesn't apply, privilege does not protect communications made to commit a crime or fraud. Lawyers must know the limits to avoid misuse of privilege. Lawyers' duty to decline disclosure: even under pressure, lawyers must resist disclosing client information unless a clear legal exception or client authorization permits it. Section 3. Conflict of interest rules: understanding conflict of interest. A conflict arises when a lawyer's responsibilities to one client are materially limited by obligations to another client, a former client, or personal interests. Types of conflicts can be current client conflicts, former client conflicts, personal interest conflicts, or prospective client conflicts, each requiring different handling under ethics rules. Duty of loyalty: lawyers must remain loyal to each client. Divided loyalties impair judgment and threaten the fairness and integrity of legal representation. Informed consent and waivers. In some cases, conflicts can be resolved with written informed consent from all affected clients. Only if the lawyer believes competent, loyal representation is still possible. Simultaneous representation issues. Representing two clients in the same matter with opposing or differing interests is usually impermissible unless all clients give informed consent. Former client conflicts: lawyers cannot represent new clients in matters substantially related to those of former clients if interests are materially adverse, unless the former client consents. Organizational clients: lawyers representing companies must remember their duty is to the organization, not individual officers or employees, especially during internal investigations. Personal interest conflicts: romantic relationships, financial investments, or family ties may create bias or appearance of bias. Such relationships must be disclosed and managed or avoided. Screening and conflict checks: law firms must implement systems to check for conflicts before taking on new clients. Screening or ethical walls may be used to protect confidentiality. Consequences of breach violating conflict rules may lead to disqualification from the case, malpractice liability, and disciplinary sanctions by the Bar Association. Section 4. Communication and client autonomy: duty to communicate. Lawyers must promptly inform clients of important developments, explain legal matters clearly, and respond to client inquiries with reasonable speed and accuracy. Keeping clients informed, clients should be updated about case status, upcoming deadlines, risks, and potential outcomes. Silence or poor communication violates ethical responsibilities. Explaining legal matters, lawyers must break down legal issues so clients understand options and consequences, enabling informed decision-making at every stage of representation. Responding to clients, lawyers must answer phone calls, emails, and letters within a reasonable time. Ignoring clients can damage trust and lead to complaints. Preserving client autonomy. While lawyers provide expertise and guidance, final decisions, such as whether to settle or plead guilty, must be made by the client, not the lawyer. Managing disagreements. If the client's wishes conflict with the lawyer's advice, the lawyer must respect the client's decision unless it violates the law or ethics rules. Withdrawal from representation. If communication fails, or if a client demands unethical conduct, lawyers may withdraw with notice, following rules to protect the client's interests. Summary and reflection. Lawyers must act competently, diligently, and ethically, always protecting confidentiality, avoiding conflicts, and honoring client autonomy. Ethical practice builds trust and strengthens the legal profession's role in justice. Module 3. Duties to the court and legal system. Section 1. Candor and honesty to the tribunal. Introduction to duties to the court. Lawyers serve as officers of the court. Their ethical duties extend beyond client advocacy to upholding the integrity of the judicial process. These duties ensure that legal proceedings remain fair, accurate, and truthful for all participants involved, including the judge and the public. What is candor to the tribunal? Candor to the tribunal means lawyers must not knowingly make false statements, mislead the court, or conceal facts. This includes presenting truthful arguments, disclosing legal authority, and correcting material errors. Candor preserves the legitimacy and function of the judicial process. Truthfulness in representations. Lawyers must always be honest when making statements of fact or law to a judge. Misstating facts or misrepresenting legal precedents, even by omission, can result in mistrials, reversed decisions, or disciplinary actions against the lawyer. Duty to correct false statements. If a lawyer learns that they have made a false statement or presented false evidence, they must take reasonable steps to correct the error. This includes notifying the court or withdrawing false arguments, even if doing so may harm their client's case. Use of evidence in court. Lawyers must not offer evidence they know to be false. If a client insists on presenting false evidence, the lawyer must attempt to dissuade them. If unsuccessful, ethical rules may require withdrawal or limited disclosure, depending on the jurisdiction. Dealing with perjury. If a lawyer knows a client intends to lie or has lied under oath, they face a difficult ethical dilemma. In many jurisdictions, the lawyer must either prevent the false testimony or notify the court while trying to protect client confidentiality. Disclosure of adverse legal authority. Ethical rules require lawyers to inform the court of legal precedent that directly contradicts their argument if the authority is from the controlling jurisdiction, even when the opposing side fails to raise it. This ensures fair, fully informed judicial decisions. Respect for the legal process. Lawyers must behave with respect in court, not just in words, but through conduct. This includes refraining from deceptive tactics, inflammatory statements, or any actions that could distort or delay the process of justice. Consequences of dishonesty. Failing to uphold honesty and candor can lead to serious consequences, including contempt of court, disciplinary sanctions, reversed judgments, or permanent damage to a lawyer's reputation and license. Case study and application. Consider a case where an attorney withheld critical evidence that harmed the opposing side's defense. Discuss how this violated the duty of candor, what should have been done differently, and how courts responded to the misconduct. Section 2. Fairness to opposing counsel and parties' overview of fairness in advocacy. Lawyers must advocate zealously for clients without compromising fairness toward opposing counsel or other parties. Ethical advocacy requires honesty, courtesy, and procedural fairness, even when legal battles are adversarial and emotionally charged. Avoiding harassment or intimidation. Lawyers must not use legal procedures to harass or intimidate opposing parties or witnesses. This includes abusive language, frivolous motions, or threats intended to pressure or harm another party unjustly. Honesty in negotiations. While lawyers are permitted to negotiate forcefully, they may not lie about material facts, settlement authority, or evidence. Bluffing is part of strategy, but crossing the line into deception violates ethical standards. Handling discovery properly. During discovery, lawyers must not hide, destroy, or delay the release of evidence they are required to produce. Ethical obligations ensure both sides have fair access to the information necessary for their case. Respect in communication. Emails, letters, and court filings must be professional and civil. Insults, sarcasm, and inflammatory language harm professional relationships and may be sanctioned if deemed abusive or obstructive to the process. Dealing fairly with witnesses. Lawyers must not coach witnesses to lie or mislead. They must also avoid improper influence, coercion, or compensation that could undermine the witness's credibility or objectivity in testimony. Trial conduct and fairness. In trial, lawyers must follow procedural rules, avoid disrupting opposing arguments, and respect evidentiary rulings. Overstepping may result in mistrials, sanctions, or reversal on appeal due to unfair proceedings. Trial conduct and fairness. In trial, lawyers must follow procedural rules, avoid disrupting opposing arguments, and respect evidentiary rulings. Overstepping may result in mistrials, sanctions, or reversal on appeal due to unfair proceedings. Rules on ex parte communication. Lawyers must not communicate directly with the judge without notifying opposing counsel, except in emergencies or authorized situations. Unauthorized ex parte contact may unfairly influence the judge or decision-making. Maintaining integrity during delay tactics. Deliberately stalling proceedings to frustrate the opposing side violates fairness. Tactics like scheduling conflicts, excessive motions, or refusal to cooperate are viewed as unethical and obstructive. Fairness case scenario analyze a case where a lawyer intentionally withheld evidence from discovery to gain advantage. Discuss the ethical violation and how it affected both the case outcome and the lawyer's standing. Section 3. Prohibition of frivolous claims and defences defining frivolous litigation. Frivolous claims are those lacking legal merit, factual basis, or good faith intent. Lawyers must not initiate lawsuits or defences they know have no chance of success or are intended to harass. Rule 11 and sanctions Federal Rule of Civil Procedure 11 penalizes attorneys for presenting frivolous pleadings or motions. Sanctions may include fines, case dismissal, or orders to pay the other party's legal fees. Distinguishing novel arguments from frivolous ones. Creative legal arguments are allowed if supported by reason and research, even if not yet accepted by courts. Frivolous claims, however, show no grounding in law or fact and waste judicial resources. Ethical rules on filing claims. The ABA model rules prohibit lawyers from bringing claims unless they are supported by law or a reasonable argument for changing existing law. Lawyers must always assess legitimacy before proceeding. Litigation as harassment lawsuits should not be used as tools of revenge, intimidation, or economic pressure. Filing cases just to exhaust or punish the opposing side violates the principle of fairness. Litigation as harassment lawsuits should not be used as tools of revenge, intimidation, or economic pressure. Filing cases just to exhaust or punish the opposing side violates the principle of fairness. Frivolous appeals and motions filed only to delay finality or exhaust the opposing party's resources can also be deemed frivolous, triggering court penalties or loss of credibility. Duty to withdraw improper claims. If evidence reveals a claim is baseless, the lawyer must withdraw or amend the argument. Continuing to press a meritless claim knowingly is unethical and may warrant discipline. Consequences of frivolous litigation. Engaging in frivolous litigation can lead to sanctions, dismissal of claims, damage to client reputation, and formal disciplinary action against the attorney. Application scenario: a lawyer files a case without researching the law, knowing the facts are weak. Was this ethical? Discuss what the lawyer should have done before filing and how courts typically respond. Section 4. Reporting misconduct. Duty to report misconduct. Lawyers must report known violations of serious ethical rules by other attorneys or judges. This duty helps protect the legal profession, clients, and the public from harm caused by unethical behavior. Threshold for reporting is required only when the violation raises a substantial question about the lawyer's honesty, trustworthiness, or fitness to practice law. Minor mistakes do not always require reporting. Confidentiality versus reporting. The duty to report does not override client confidentiality. Lawyers may not reveal protected client information to report misconduct unless the client consents or an exception applies. How to report misconduct. Reports should be made to the appropriate disciplinary authority. Some jurisdictions allow anonymous reporting, but credible, detailed submissions are more effective and taken more seriously. Consequences of failing to report serious misconduct may itself violate ethical rules. Lawyers who ignore egregious behavior risk being seen as complicit and may face discipline for silence. Protecting whistleblowers. Lawyers who report misconduct in good faith are typically protected from retaliation. However, they must be cautious to report only when reasonably certain that wrongdoing has occurred. Examples of reportable violations. Examples include embezzling client funds, lying to a court, covering up evidence, or committing crimes. These violations strike at the heart of ethical legal practice and must be reported. Recap and discussion lawyers must remain honest with the court, fair to others, avoid baseless claims, and report serious wrongdoing. Discuss. What would you do if a colleague lied to a judge in your presence? Module 4. Professional Responsibility and Practice Management. Section 1. Advertising and Solicitation Rules Introduction to Legal Advertising. Lawyer advertising includes any public communication about legal services. While permitted, it must be truthful, non-deceptive, and respectful of the public. Ethics rules balance lawyer free speech with consumer protection from false or misleading statements. Purpose of regulation advertising rules exist to prevent exploitation of vulnerable individuals, misleading claims, or unfair competition. Lawyers must not create unrealistic expectations or misrepresent their experience, fees, or outcomes through ads or online content. Truthfulness in advertising statements in ads must be accurate. Lawyers must avoid promising specific case outcomes or comparing their services to others unless claims can be factually verified. Puffery and misleading visuals are also prohibited under many bar rules. Required disclaimers. Certain ads must include disclaimers such as prior results do not guarantee future outcomes. These disclaimers help consumers understand that legal results depend on individual circumstances, not attorney marketing. Online and social media advertising digital platforms must follow the same ethical rules. Posts, videos, blogs, or LinkedIn profiles promoting legal services must be honest, include required contact details, and avoid manipulating search engines or misleading viewers. What is solicitation? Solicitation refers to direct, targeted outreach to potential clients, often through personal contact, email, or letters. While general advertising is allowed, solicitation has stricter rules to prevent undue pressure or harassment. Prohibited solicitation practices. Lawyers may not solicit clients in real time if the contact is coercive, involves deception, or targets vulnerable individuals like accident victims shortly after incidents. Permissible solicitation, non-coercive written communication, is generally allowed, but it must be labelled as advertising material and comply with jurisdiction-specific rules. Lawyers must maintain records of such outreach for possible review. Paying for referrals. Lawyers cannot pay others to refer clients unless it's part of an approved legal referral service. Fee sharing with non-lawyers in exchange for client leads is strictly prohibited under professional conduct rules. Advertising case study. A lawyer posts a video claiming he never loses cases. This could be misleading and violate advertising rules. Discuss how the ad could be reframed to promote services ethically and legally. Section 2. Handling client funds and trust accounts. Lawyers' role as financial fiduciary. Lawyers often handle money on behalf of clients. Ethical rules require strict protection and separation of these funds. Mishandling client funds is one of the most common and serious ethical violations. Trust account basics. Client funds must be deposited into a separate trust or IOLTA. These accounts cannot be used for personal or law firm expenses under any circumstances. What belongs in a trust account. Funds such as unearned fees, settlement checks, advanced costs, or escrow deposits must be placed in the client trust account until properly earned or distributed. Commingling prohibited. Lawyers must not mix client funds with personal or firm funds. This commingling can result in audits, bar sanctions, or accusations of theft, even without actual misuse of money. Timely disbursement. Lawyers must promptly disburse funds to clients or third parties after the matter concludes. Delays in distribution without cause can lead to grievances or financial liability. Accurate accounting records. Lawyers must keep detailed records of trust account activity, including deposits, disbursements, and balances. These records must be retained for several years, depending on jurisdictional rules. Fees and withdrawals. A lawyer may only withdraw earned fees from a trust account after proper billing. Disputes over fees must be handled cautiously, lawyers cannot unilaterally remove contested amounts. Handling third-party claims. If a third party has a claim to part of the client's funds, the lawyer must hold the disputed amount in trust until resolved. Trust account misuse examples. Taking money early, failing to deposit, or using funds to pay firm bills are major violations. Discuss real cases where lawyers face suspension or disbarment due to fund mismanagement. Best practices summary. Always separate accounts, document every transaction, get written fee agreements, and reconcile balances monthly. Even small mistakes can carry serious consequences if patterns of negligence or dishonesty are proven. Section 3. Supervision of non-lawyer staff. Ethical responsibility. For supervision, lawyers are responsible for ensuring that paralegals, assistants, and other staff comply with ethics rules. Delegating tasks does not remove the lawyer's personal accountability for the results or conduct of their team. Permissible non-lawyer tasks. Non-lawyers may handle administrative tasks, client scheduling, drafting documents, and legal research under direct supervision. However, they cannot give legal advice, represent clients in court, or sign legal pleadings. Unauthorized practice of law. Allowing non-lawyers to provide legal services constitutes unauthorized practice of law. Lawyers who supervise such conduct can face serious penalties, including loss of license or criminal charges. Clear role boundaries. Lawyers must clearly explain to clients that non-lawyer staff are support personnel, not licensed attorneys. Clients should never be misled about who is handling their case. Training and policies. Firms must establish policies and regular training to ensure staff understand ethical rules, confidentiality requirements, and their limitations. Lack of training increases the risk of errors and misconduct. Monitoring work product. Lawyers must review all legal work done by non-lawyers before filing or sending to clients. Supervision includes quality control and ensuring ethical compliance throughout all stages of work. Confidentiality obligations. Non-lawyer staff must protect client information just like attorneys. Lawyers must educate their staff on the importance of privacy, especially when handling digital files, emails, or court documents. Mistakes and misconduct by staff. If a paralegal misses a filing deadline or sends confidential files to the wrong recipient, the lawyer remains responsible. Ethics rules hold attorneys accountable for their team's failures. Technology and virtual assistants, remote and AI-based staff tools are increasingly common. Lawyers must ensure these tools do not breach confidentiality, offer unauthorized advice, or process legal tasks beyond their scope. Scenario on delegation. A legal assistant gives advice on a custody case to a client. Discuss the ethical implications and what the supervising attorney should do to correct the situation and prevent recurrence. Section 4. Maintaining professionalism and avoiding misconduct. Defining professionalism. Professionalism includes respectful communication, ethical conduct, accountability, and decorum in all legal settings. It reflects how lawyers carry themselves and interact with clients, courts, colleagues, and the public. Civility toward others. Lawyers must treat opposing counsel, clients, witnesses, and the judiciary with courtesy and respect. Rudeness, threats, or inflammatory remarks erode the legal system's integrity and can result in sanctions. Substance abuse and competence. Substance abuse or mental health struggles that impair legal judgment can lead to ethical violations. Lawyers have a duty to seek help and may face mandatory reporting or intervention programs. Avoiding misconduct. Misconduct includes fraud, dishonesty, criminal activity, sexual harassment, and repeated violation of court orders. Ethics rules apply both inside and outside legal representation, including social or personal conduct. Dealing with stress and burnout. Lawyers are more effective and ethical when mentally, and physically healthy. Burnout can cause negligence, poor communication, or ethical lapses. Managing workload and wellness is a professional responsibility. Public and online behavior statements made in public, on blogs or social media must uphold professionalism. Revealing client details online, mocking judges, or using hate speech, even outside court, can violate professional standards. Sanctions for unprofessional conduct, unprofessional behavior may lead to bar complaints, client loss, damaged reputation, or disciplinary action ranging from warnings to disbarment, depending on the severity and recurrence of misconduct. Summary and ethical reflection lawyers must maintain high ethical standards in business, supervision, communication, and personal conduct. Discuss: how can a lawyer maintain professionalism under pressure or when faced with an unethical opposing counsel? Module 5, Ethics Violations and Discipline. Section 1. Common ethical violations. Introduction to ethics. Violations. Ethics violations involve breaches of professional conduct that harm clients, courts, or the profession. These may be intentional or due to carelessness, but always carry serious consequences. Recognizing common violations helps prevent future misconduct and promotes a culture of responsibility in legal practice. Neglecting client matters. One of the most frequent complaints is a lawyer's failure to act diligently, missing deadlines, ignoring communications, or letting cases stagnate. This reflects poor service, damages client interests, and may result in suspension or malpractice claims. Mishandling client funds, improperly using or failing to safeguard client funds is a severe ethical violation. This includes commingling funds, failing to account for money, or delaying payment. Even accidental misuse can lead to disciplinary action or disbarment. Conflicts of interest representing clients with opposing interests or allowing personal interests to influence decisions can compromise loyalty. Failing to disclose or manage conflicts, even unintentionally, often results in ethical charges and client harm. Lack of communication. Clients have the right to timely updates and explanations. Ignoring calls, Failing to explain legal options or not informing clients of key developments can erode trust and result in formal complaints to the bar. Unauthorized practice of law practicing without a license, working outside authorized jurisdictions, or allowing non-lawyers to offer legal advice constitutes UPL. These actions threaten the integrity of the profession and often carry legal penalties. Misleading advertising or solicitation, false promises, misleading claims, or improper solicitation, especially in personal injury or vulnerable communities, violate ethical rules. Lawyers must always ensure their marketing is honest and complies with all jurisdictional requirements. Breach of confidentiality, disclosing client information without consent, even accidentally, violates the core duty of confidentiality. This applies in conversations, emails, social media, and public settings. A single slip can cause serious harm and liability. Criminal conduct or fraud. Lawyers who engage in criminal acts, including fraud, embezzlement, or obstruction of justice, face both criminal charges and disciplinary proceedings. Convictions almost always lead to disbarment and permanent loss of license. Case study discussion. Discuss a real or hypothetical case where a lawyer was suspended for mishandling trust funds. What warning signs were missed? How could the lawyer have avoided the situation? What should other lawyers learn from it? Section 2. Disciplinary processes and sanctions. Overview of lawyer discipline systems. Every jurisdiction has a disciplinary system to investigate, prosecute, and punish lawyer misconduct. The process is meant to protect the public, maintain trust in the profession, and rehabilitate lawyers where possible. How complaints are filed. Disciplinary actions typically begin with a written complaint to the state bar or regulatory agency. Anyone, client, judge, opposing party, can file a complaint alleging a breach of ethics or misconduct. Screening and investigation. Bar counsel or ethics staff screen each complaint. If credible, they investigate by gathering documents, emails, court records, and conducting interviews. Some complaints are dismissed if they lack merit or involve minor errors. Formal charges and hearings. If probable cause is found, formal charges are filed. the lawyer has the right to respond and appear at a disciplinary hearing. This process includes evidence presentation, witness testimony, and argument before a panel or judge. Rights of the accused lawyers facing charges are entitled to notice, counsel, a fair hearing, and an opportunity to appeal. These rights ensure the process is just and that punishments are based on factual findings and legal standards. Possible sanctions range from private admonitions to disbarment. Common penalties include public reprimand, suspension from practice, mandatory ethics training, probation, restitution to clients, and permanent loss of license. Suspension versus disbarment. Suspension is temporary and may come with conditions for reinstatement. Disbarment is the most severe penalty, often permanent, and reflects conduct that makes the lawyer unfit to practice again. Mitigating and aggravating factors. Disciplinary bodies consider mitigating factors and aggravating factors. These influence the type and severity of sanction imposed. Transparency and public discipline. Most disciplinary records are public to maintain transparency and allow clients to make informed decisions. Some minor sanctions may remain confidential depending on local rules. Flowchart activity. Create a flowchart of the disciplinary process, from complaint filing to final ruling. Identify where lawyers can cooperate or intervene to reduce consequences, and what happens at each procedural stage. Section 3. Role of bar associations. What are bar associations? Bar associations are legal regulatory bodies responsible for licensing, monitoring, and disciplining lawyers. They may also provide education, ethics guidance, advocacy, and support for legal professionals within a jurisdiction. Bar versus voluntary associations. Mandatory bars regulate licensing and discipline. Voluntary bar associations offer member services like CLE and networking, but lack regulatory power. Some states separate these functions. Disciplinary authority of the bar. Most state bars or their professional responsibility offices investigate ethical complaints. conduct disciplinary proceedings, and enforce rules. They operate under authority granted by the courts or legislature. Ethics committees and opinions ethics committees issue advisory opinions to help lawyers navigate grey areas. While often non-binding, these opinions guide ethical behaviour and help prevent future violations. Lawyer assistance programs. Many bar associations offer confidential support programs for lawyers dealing with addiction, depression, stress, or other impairments. Seeking help early can prevent misconduct and protect client interests. Continuing legal education bars mandate CLE in ethics to ensure lawyers stay informed on evolving rules and standards. Failure to complete required hours may lead to penalties or loss of good standing. Oversight of law practice standards. Some bars audit trust accounts, require annual filings, or review firm structures to ensure ethical compliance. These proactive efforts aim to detect problems before harm occurs. Promoting diversity and inclusion. Modern bar associations also focus on ethical fairness through diversity initiatives. They support equal access to justice and professionalism across backgrounds, contributing to a healthier legal system. Discipline in federal versus state bars. A lawyer admitted in multiple jurisdictions may face discipline in all if misconduct occurs. Federal bars can discipline attorneys separately, particularly for misconduct in federal court. Reflection prompt. What would you do if a fellow attorney repeatedly ignored ethics training or client complaints? Discuss how bar resources, reporting mechanisms, or informal peer support could help resolve the issue. Section 4. Preventive strategies for ethical compliance. Why prevention matters. Preventing ethics violations is more effective than dealing with consequences. Prevention protects clients, enhances firm reputation, reduces liability, and promotes trust in the legal system. It is a daily commitment, not a one-time task. Developing an ethics checklist. Law firms should use checklists covering client intake, conflict checks, billing practices, confidentiality protocols, and deadlines. Standard procedures reduce errors and help spot risk before misconduct occurs. Office culture and leadership. Creating a culture of integrity begins with leadership. Senior lawyers must model ethical behavior, address problems transparently, and encourage junior staff to raise concerns without fear of retaliation. Conflict of interest controls. Always run conflict checks before accepting a new client or matter. Maintain an updated conflict database and train all staff to recognize red flags during client intake. Confidentiality protocols secure physical and digital files. Use encrypted communication. Hold training sessions on avoiding unintentional breaches, especially in open office environments or during remote work. Billing transparency and honesty ensure timekeeping is accurate and fees are reasonable. Use written agreements that explain scope, rates, and responsibilities. Clients should never be surprised by invoices or confused about billing items. Routine ethics audits conduct regular internal reviews of firm operations, evaluate trust accounts, email security, calendaring systems, and staff roles. Ethics audits identify weaknesses and prevent minor issues from escalating into violations. Final recap and discussion ethical practice requires daily awareness, firm-wide policies, and personal integrity. Reflect on what preventive steps can you take today to reduce future ethical risk in your practice or team. Module 6, Case Studies and Review Quiz. Section 1. Hypothetical ethics scenario. Candor to the tribunal. An attorney knows their client intends to lie on the witness stand in a criminal trial. The lawyer has warned the client, but the client insists. What should the lawyer do under the rules of candor and truthfulness? Scenario 2. Handling client funds. A lawyer accidentally uses money from a client trust account to pay firm rent, believing they'd reimburse it immediately. The funds are restored 2 days later, Question: has a violation occurred? Why or why not? Scenario 3, conflict of interest. A lawyer is asked to represent a new client in a matter directly related to a former client's confidential case from 2 years ago. Question: what steps must the lawyer take before accepting this representation? Scenario 4, supervision of staff. A paralegal at a small firm sends legal advice to a client via email without review from an attorney. The client later relies on this advice in court. Who is responsible for this violation and what should have been done? Scenario 5, solicitation rules. A lawyer contacts victims of a car crash the same day it happens using direct messages on social media, offering legal help and discounts. Question: does this constitute improper solicitation? Explain using the ethical framework. Section 2. Ethical Dilemma Discussions. Dilemma 1. Conflicting duties. Your client confesses guilt in a criminal matter but insists on pleading not guilty and testifying otherwise. Discussion prompt. How do you balance the duty of loyalty with the duty to the court? Dilemma 2. Reporting misconduct. You discover that a colleague in your firm is knowingly overbilling clients. They ask you not to say anything and offer to correct the bills. Discussion prompt. Do you have a duty to report? To whom? Dilemma 3. Confidentiality versus harm. A client reveals plans to harm a third party. You are bound by confidentiality, but the threat is serious and imminent. Discussion prompt. When can a lawyer break confidentiality under the harm exception? Dilemma 4. Advertising integrity. You're launching a website and want to include testimonials like best lawyer in town and past success stories. Discussion prompt. What are the ethical rules around advertising claims and client endorsements? Section 3. 10-question ethics. Review quiz questions 1 to Q1. A lawyer can never reveal confidential client information under any circumstances. Q2. Which of the following would most likely violate the rule against frivolous claims? A. A novel argument on unsettled law. B. A baseless lawsuit filed to harass. C. A strong but risky dense. D. All of the above. Quiz questions 3 for Q3. Which scenario requires immediate withdrawal from representation? A. Client insists on illegal conduct. B. Client stops paying fees. C. Lawyer feels emotionally drained. D. Client wants to switch firms. Q4. Explain what commingling of funds means and why it's unethical. Quiz questions 5, 6, Q5. A lawyer must report another lawyer's serious ethical violation, even if they fear damaging the relationship. Q6. What must a lawyer do before accepting a case against a former client? Nothing, if years have passed. B. Ask current client for consent. C. Obtain written consent from the former client. D. Only notify the former client. Quiz question 7, 8Q7. Which of the following is not a role of bar associations? A. Approving judicial rulings. B. Licensing attorneys. C. Enforcing disciplinary rules. D. Offering continuing education. Q8. Give one example of how a lawyer can prevent unintentional confidentiality breaches in remote work environments. Quiz questions 9, 10Q9. A lawyer sees a colleague falsify a contract for submission in court. The lawyer should A. Stay silent. B. Confront but not report. C. Report to disciplinary authority. D. Tell a judge directly. Q10. A lawyer may advertise past case results as guarantees if the outcomes were successful and well documented. Final recap and call to integrity. Ethical lawyering is more than rules. It's a commitment to trust, fairness, and justice. Through competence, honesty, confidentiality, and professionalism, lawyers serve the court, clients, and society. Reflect on your role. What kind of ethical lawyer do you want to become? Thank you.